कोशिश करते हैं कि जुडिशरी से हीरे चुने और ऐसे हीरे लेके आएँ जो सब्जेक्ट पे आपको और बाकी वकला को जो अभी तक नहीं आए या ऑनलाइन स्टडी करना चाहते हैं उनकी हम कैपेसिटी बिल्डिंग करें। हम उनमें वकालत के प्रोफेशन में उनमें कॉम्पिटेंसी लाएँ। तो आज इस सिलसिले में जनाब मोहतरम इस्माइल तस्लीम अख्तर साहब जो हमारे बहुत ही कॉम्पिटेंट, बहुत ही ऑनेस्ट और बहुत ज़बरदस्त जज हैं और जो इंटेलेक्चुअल वर्क भी करते हैं, आज हमने उनको दावत दी है कि हमें आएँ और हमें पार्टीशन पे लेक्चर दें, हमारे कंसेप्ट क्लियर करें, हमें शेयर करें नॉलेज, ताकि हम आगे इसमें जितनी इनोवेशंस आ रही हैं, जितने नए कानून आए हैं उनसे हम सीखें। तो हम आज उन्हें और उनके साथ जनाब फ़याज़ अहमद मोल साहब एडिशनल सेशन जज साहब को रिक्वेस्ट करते हैं कि वो हमें, आज उन्होंने ज्वाइन किया है, हम उनकी बेइंतहा इज़्ज़त करते हैं और हम कभी उनसे भी रिक्वेस्ट करेंगे कि हमें इस सिलसिले की कड़ी में हमारे साथ वो भी शामिल हों और हमें वो भी लेक्चर दें। तो सबसे पहले मैं रिक्वेस्ट करूंगा मुतैर शाह साहब से कि इस्माइल तस्लीम अख्तर साहब को बुक्के पेश करें। अब मैं जनाब सीनियर सिविल जज साहब जनाब इस्माइल तस्लीम अख्तर साहब से रिक्वेस्ट करूंगा कि वो आएँ और अपना नॉलेज हमारे साथ शेयर करें। मेहरबानी।
थैंक यू। औज़ु बिल्लाहि मिनश शैतानिर रजीम, बिस्मिल्लाहिर रहमानिर रहीम। ऑनरेबल प्रेसिडियम, distinguished participants, assalamu alaikum. Sharing knowledge is a very simple phenomena, but gathering knowledge is very difficult. It's always been a lust which develops the concept of gathering knowledge. You all are young people sitting over here having extraordinary career in front of you, but it is always difficult to learn once you have no motivation for that. I'm really grateful to the President District Bar Association Jhang and all the participants present here that I've been given that honor to share my knowledge, which is very much meager in my own wisdom. So I will try my level best if I'll be able to provide any sort of assistance to my learned colleagues. The Punjab Partition of Immovable Property Act was promulgated in the year 2012. Earlier to that, there was a Partition Act 1893, which was in field and it remains in field for many decades, as everybody knows that. But while repealing the provisions of the Partition Act 1893, the law was given a retrospective effect, and section 17 of the act speaks out volume about that particular aspect, and it states the Partition Act 1893 is hereby repealed, and its part 2 says, notwithstanding the repeal of the Partition Act and without prejudice to any provision, proceedings in a suit, the suit for partition of immovable property pending in any court under the repealed act shall be proceeded with and decided by the court in accordance with the provisions of this act. Now I will straight away refer that how the proceedings in a suit for partition of immovable property will be dealt under the latest law. The relevant laws are, please sir, slides. The relevant laws are obviously the Punjab Partition of Immovable Property Act 2012, the Code of Civil Procedure 1898, the Court Fee Act 1870 and the Suit Valuation Act 1887. I have referred to certain case laws. There is no much development in this particular field till date, as I am still afraid that no much judgments have been reported to the superior courts, as this law has a very speedy remedy available within it. and the concept is to evaluate the actual dispute interested the parties, and that is only partition. The analysis and answers to the queries shall be that the suit shall be instituted under section 4 of the Act. Prior to dealing further with this particular provision, I would like to address to the audience that by virtue of the Act itself, it has been provided that it shall not deal with the agricultural land. So the only land which shall be dealt with by this law is not the agricultural land or the land subservient to agriculture. So after the exclusion of the same, as it was been earlier held by the Honorable Superior Courts, though there are certain judgments where it has been held by the Honorable Apex Courts that once some portion of the agricultural land left its credibility as agricultural or subservient to agriculture, the civil court being ultimate jurisdiction shall deal with the suits. But now by virtue of section 2 of the present Act, the limitation on scope is quite much clear, which states that no agricultural land or land subservient to agriculture shall be included in the partition suit under the Act 2012. Definition specifically speaks about the law itself or the meaning given to the particular provisions or some particular areas. Section 3 specifically speaks out that the code means the code of civil procedure. So all the procedure, all the analogies provided under the code shall be dealt with while dealing with the suit. So after the institution of the suit, there is a legal maxim that's called nemo inconveniens potest inimitis deteneris. No one can be kept in co-proprietorship against his will. Partition is merely an arrangement whereby co-sharers having undivided interest in joint properties take by arrangements specific properties in lieu of their shares. The law is now well settled that each and every co-sharer shall be deemed to have the owner and in constructive possession of every single inch of the joint corpus. Such fact was earlier been dealt under the previous law of 1893. It is still in existence since all the proceedings are now to be adopted by the present Act. So every co-sharer is in joint ownership and his constructive possession is by virtue of the possession of the co-sharer. At first, आप काफ़ी आगे चले गए बेटे, वापस आना पड़ेगा मैक्सिम की बात, मैक्सिम से आगे. हाँ जी. The first portion is the examination of the plaint. If you go through the provisions of law of the Act 2012, it speaks out volumes that whenever a suit for partition of immovable property is being filed, it shall state the details of the property. And those details include each and every number, each and every dimension, and every single corner of that property. You cannot exclude any portion by stating that I am in dispute with one co-sharer, so other are excluded, as it normally happens in certain suits which has been filed by the Learned Counsel. But the law states that you have to detail the whole property in filing a suit for partition. And that apart from that, you have also to cite all the other co-sharers, not to exclude anyone from there. The completion of annexed documents, it connotes basically that every document which is relevant to your suit or relevant to that particular property in your possession or in your domain shall be enclosed along with the plaint, and this is now a sine qua non that you are not authorized to keep it in your pocket to introduce it subsequently. The reason I will discuss subsequently. Court fee is very simple in this particular case. It is a dual valuation suit. Whenever a suit for partition is filed, it has been dual valued. For the purposes of court fee, it has been fixed at ₹10 by virtue of section 9 of the Suit Valuation Act, for the reasons that section 9 Suit Valuation Act says that certain values shall be determined by the Honorable Lahore High Court, Lahore. And for that matter, the Honorable Lahore High Court, while making certain rules, introduced Rule 8. Its A part says that court fee on a suit for partition shall be according to the Court Fee Act. Now the Court Fee Act says in a suit for partition only 10 rupees court fee is required. Muhammad Hanif versus Hashmat Banu and others, PLD 2015, Sindh 356 also envisaged and contemplates this particular fact that the court fee of rupees 10 shall be inculcated or inserted in the suit for partition. So far as the valuation for the purposes of jurisdiction is concerned, this is normally, Shah Sahab will let you know about it. It was a common practice earlier when the suits were filed that there were two valuations. That is why I am saying it is dual value suit. They always states a suit is valued for the purposes of court fee for at rupees only 10, since only 10 rupees is required to be appended or affixed. But for the purposes of jurisdiction, the entire value of the land shall be determined by the plaintiff at the time of filing of the suit, and that will be the basic concept that which court holds the jurisdiction to decide such less. Normally we values it on the share of the plaintiff or rupees 10,000 or 10,000 or 20,000, 25,000, but it is not the case, sir. You have to value it on the entire value of the land, and that is only for the purposes of jurisdiction to ascertain which court of civil jurisdiction shall entertain the suit, as there are three classes provided under the law. Next comes the process, how after examining the plaint, the court shall proceed on with the case. There is a prescribed notice under the provisions provided, which shall be accompanied through a registered post or TCS, etc. The process is left with the court. Etc. means you are authorized by virtue of that law that certain procedures to be adopted, including latest technologies, to make service abundant on the particular defendants, but it shall not be later than 10 days. Next please. Ex parte proceedings. Section 5 further makes it very clear that if a defendant fails to appear in the court and it is to the satisfaction of the court that he has actually been served, the proceedings of ex parte shall be initiated. Now this is one part. The second part is of most significance. We are normally not looking into it. Once the defendant came to know about such ex parte proceedings, he is required under the law to file an application within 15 days from the date of his knowledge. First, sine qua non is that not later than 15 days. Second, and that is the most important one, he has to accompany his written statement and all the documents in his possession to be accompanied with that application for setting aside ex parte proceedings. And subsequently the court, if considers appropriate, can set aside the ex parte proceedings. But if no such written statement has been annexed with the same, section 6 will come into force. Though it is not directly provided in the law, but the definition which has been given in the law itself, it says subject to section 5. Now it is connoting with the previous section. Section 6 will come into existence with section 5, and section 6 states that if the defendant has joined the proceedings, he is required to file written statement within 30 days along with all the documents in his possession, and if he fails to do so, the consequence will arise, and that consequence is that his defense shall be struck off. So if he fails to submit an application or to submit a written statement accompanying with the application for setting aside ex parte proceedings, his defense shall be struck off. It is very simplicity. For that matter, he is also not entitled to lead any evidence. I have referred to the case of Raja Muhammad Amir Khan and another versus Raja Sher Afzal Jasmine Michael Khan through Special Attorney and 4 others in 2018 YLR 487 Lahore. It was been way back held that once defense is struck off, the defendant is not entitled to lead any sort of evidence in support of his claim. Written statement is almost identical to that, as I have already discussed it with you. Then comes the means profit. This is one thing which is normally ignorant even by the courts itself, for simplest reasons that we are becoming a dilemma of practices. A practice is only which has been envisaged under the law, which has been provided under the law, which has been the legislative intent. No other practice is a practice under legal denomination. Means profit is dealt by section 7. It is actually approximate rental value of the property. What is the purpose behind it? To allow the co-sharer out of possession a chance that there shall be a benefit in his pocket in respect of rental value which he has been deprived of by the person holding the possession of the land or the property. It shall connote that it shall be passed on the first date of hearing, but it is a discretion now provided by the court. In certain circumstances, if the court considers that the defendant is more appropriate to be heard before passing any such order, it is required to be mentioned or inculcated in the order sheet. Otherwise, it states on the first date of hearing, the court may direct the co-owner in possession of the property to deposit means profit. It has also been called meccine profits. Don't shy while speaking in English. We have every authority to break the legs of English language since they are damaging the language of Urdu. So we are at liberty for that. But since it is a Latin word, it has been pronounced twice. If you will open the Google, you will search it out. It is means profit. At the same time, it is also called meccine profits. The court can pass the order for such means profits on monthly or quarterly basis, on or before the date fixed by the court, and not beyond the date of 15th of month or first month of every quarter. The determining factors may be tentative assessment, and rental value of identical property may become the reason for determining such rental values, for determining the means profit of a property during the pendency of the lease. Consequences has also been envisaged in section 7, and it states if it is the plaintiff, his suit shall be dismissed, and if it is a defendant, his defense shall be striked out. Consequential further proceedings, no evidence. Now comes the actual difference between the earlier Partition Act and the present promulgated in 2012. Normally, whenever a written statement has been submitted in the court is required to frame issues according to the divergent pleadings of the parties and then to proceed on, allowing the parties to lead their respective end and then to decide it. This is not the case in this particular act. The only ground for initiating further proceedings of evidence or trial is a dispute as to title. This particular section also brings on record or brings into mind one very clear picture that there has to be a title of the property. If there is none, there is no suit. This act will not go into the possessory rights of the parties. Earlier, it was been held by honorable superior courts that even the possessory rights can be partitioned. He normally does that under the previous law. But after the promulgation of Act 2012, the court is only entitled to decide the suits for partition of properties not falling within the definition of agricultural land or land subservient to agriculture when there is a clear title interest the parties qua the suit property. Now, if a question arises that there is a dispute as to particular to the title, we have to clarify ourselves on this particular point. The proceedings will culminate in a very slipshod manner once we understand that. Title means authority or right to hold the property. Title does not mean that I have paid certain bills of his, I have paid for the lien of the defendant, or I have paid for the lien of the plaintiff, vice versa. Title means entitlement, authority to hold the property as an owner. And if there is no such dispute, the barrier will cross and there will be no issues and no evidence at all. The court will evaluate the documents enclosed by the parties in their respective possession and consequent thereto shall only be required in my wisdom to determine the share of the parties. This is what not been mentioned in the law itself, but you are required to determine the share of the parties to further proceed on. If you are not sure what is the share of a party, it will definitely affect the further proceedings. Next please. Once I have already told you there is no dispute as to title. What will be the procedure adopted by the court? The court shall appoint a referee under section 9. ये थोड़ा सा एक बड़ा खूबसूरत बैरियर फर्दर बनाया गया. It requires agreement, it requires consent and written consent in fact of all the co-owners. It is sine qua non that every co-sharer, a co-owner of the property, not only co-sharer but a co-owner of the property, shall give his consent in writing that I want some person to be appointed as a referee. The court is not even authorized by the law to appoint a referee out of the choices given by the parties. They have to give consent for one referee to be appointed for determination of the facts and what reference which can be given to him. With writing consent of the co-owners, the reference will be given that whether the property is partiable, and if so, what should be the equitable mode of partition. Even proposed share can be combined by virtue of consent of two or more co-owners. It is provided in section 9(4) of the Act. The next portion is court in case of partitionable property is bound to see that the proposed share is equal in all respects. This is one thing which has already been ignored even by us or even by the other authorities. Proposed share are equal in all respects. It has been held in Abdul Haq's case, reported in PLD 2022, Lahore 766, that equal in all share means valuation of property is equal of each sharer according to his or her share. A right of easement are equally available to all sharers. All sharers have the equal opportunity to utilize their shares, and the future aspect of each share is equal in all respects. It doesn't mean that every portion of land should be equal. It means that all the fruits coming out of the property is available to each sharer to its full swing, and he should enjoy it to the full extent. If somebody is deprived and the other got some benefit, then there has to be some beneficial interest given back to that particular defendant or plaintiff who has been deprived of some sort of share of the fruits of the property. In case the proposals given by the referee accepted to the parties, there is an affirmation of that proposal under section 9(5), and the only exception under the law available by virtue of judgments or otherwise is it is contrary to any law. You are not authorized to override any other law for extending benefits of partition to the co-sharers. Next please. The parties have failed to arrive at any sort of settlement in respect of a referee. The next proceedings under section 10 is internal auction. Once the parties fail to file a written agreement for appointment of referee, the opinion of referee property not partitionable, these two grounds will be considered by the court while further proceeding with the case for internal auction. There is no written consent. Second, the property is not partitionable by virtue of metes and bounds as provided earlier. The next procedure to be adopted by the court is the court shall determine the reserve price and consequent thereto shall order sale through internal auction. Now law is again silent on this part. Once internal auction is ordered, the parties are required to participate. To my humble wisdom, to my understanding of the law, now there has to be some sort of mechanism developed by the court in the order sheet how that proceeding shall be conducted, which time, which date, which place, and how the parties will participate. If we'll do that, being a counsel, ask the court to frame some sort of schedule, so that schedule should be followed by the parties at the date of hearing when internal auction is to be conducted. It will not only facilitate the parties but also facilitate the learned counsel for the parties to give them the understanding how the internal auction will proceed on. Here the parties have to appear or their authorized agents. You all are the authorized agents. The only addition to that particular fact is that under the Power of Attorney Act, you are not authorized, or by virtue of Order 33, you are not authorized agent to participate in the auction proceedings. You have to just take a simple certificate from that party that you are authorized to appear on my behalf on the particular date and to participate in the auction proceedings. And if some stipulations are being made in respect of the auction amount, that will be introduced in that particular letter. If not, then you are open to bid it at any level. Now, how the internal auction shall be considered: joining of proceedings by the co-owners, authorized agents in the court premises, a record to be maintained. That is important thing. How record will be maintained if there is no schedule provided by the law, by the court itself. So there has to be some schedule which is to be followed, and then there will be a record coming out of that particular proceedings. Written offers by two or more or counter offers of the same nature can be made by the parties, and the successful bidder shall deposit the auction price within 15 days, that has been included in the law, but exclusion to his own share. Now this is what I was talking earlier. No share has been determined. There is no exclusion of share. We have to understand the wisdom of the legislative authorities, the intent which has been followed by them while inculcating or promulgating the law, that they are requiring he can exclude his own share. If I have not determined the share of the parties, I will not be able to exclude or allow to exclude the share of the party who has made the successful bid. Then there will be confirmation of sale under section 9(6). Consequent thereto, possession of the property shall be delivered to the court auctioneer and auction purchaser, and distribution of shares shall be made amongst the co-sharers. What will be the consequence of non-deposit? The court shall fix a new date for auction, and the previous auction purchaser shall not be entitled to participate. This is one of the beauty of this particular proceedings. Nobody will be allowed to stretch with the court proceedings. If he fails to follow the schedule provided by the law, if he fails to honor his own words or the words of his authorized agents, he will be excluded from that proceedings, and he cannot claim anything for that matter. And if record is maintained properly, even if he will go to the higher forums, there will be no courtesy available to him. Consequence of failure of the internal auction. Section 11 provides that where the co-owners fail to participate in the internal auction, or the internal auction itself fails, the court shall then go to the open auction. Procedure has been provided under the law. The court shall fix the reserve price as it has been done earlier. Direct open auction through auctioneer. Co-owner may participate. Now earlier he was required to take permission from the court. Every co-sharer was entitled to participate in the external auction, but with the prior written permission of the court. Now it says that the co-sharer may participate in the auction proceedings. Appointment of court auctioneer shall be by the court. Presentation of auction plan in the form of public notice. Now this has been done orally by us earlier, but it is now provided by the law itself. The approval of plan and its publication. The court shall approve that plan which has been submitted by the court auctioneer, and after that approval it will be publicly published for the general public as well as to the participants or the co-sharers to participate, and deposit of security money for such participation shall also be fixed. 20% on the close of bidding of highest bidder and remaining within 7 days through check, cash, demand draft. Law itself provides you can adopt 3 methodologies: cash, check or demand draft, to make the payments within 7 days consequent to the acceptance of the open bid. In case of success, the sale shall be confirmed under section 11(9), and deposit shall be confirmed by virtue of sale confirmation. And consequence of failure, the amount deposited 20% shall be forfeited and fresh plan shall be given. There is another section called final settlement. It is also dealing with the court soon after the external auction is completed, the court is satisfied, final payment plan has been adopted, the court shall also distribute the means profit ordered to be deposited by each or either of the party. During such proceedings, section 13 will also come into existence, and it states private settlement. It can be done at any stage of the proceedings, but before open auction and consequent to such settlement intercede the parties, the court shall pass a decree. The time frame has been provided within 6 months to be dealt with, and this is all what I have in my pocket. I'm not sure that I have been able to address the wisdom of every person sitting over here, including Shah Sahab. I think he's the master of his art, but I hope and pray it might be some sort of helpful to all of you in future perspectives. Thank you very much.